Now, the next question we want to discuss is that when relationship ceases, what happens? I'll give you an example of the cases that I handled. The relationship was genuine, of course, and they applied for partner visa, broke down, and then got back together. 820 was granted. They had a child. All right. But then the sponsor met another man. I think things are just not working out. The relationship broke down again. They actually got divorced. The divorce happened before they launched further information for the permanent visa. And they didn't tell us. The applicant didn't tell us. The sponsor didn't tell us. The sponsor want to help the applicant to get PR for the sake of the child. So neither of them told us. The sponsor was cooperating, of course. And then the department somehow discovered that they got divorced already. And I asked them, they show me the divorce paper. The divorce paper was before submitting further information, including statutory declaration of the relationship is continuing for the PR. Relationship broke down, divorced, provided false information to get PR. So the department discovered that and sent over not only that your visa should be refused, but also a public interest criteria 4020, you provided misleading information. And then we were shocked when we look at that because we didn't even know. How do we handle it? We told the client that, look, you have a child. You actually have a child. Because you have custody or access to your child, you're eligible for PR already. You just didn't tell us. If you told us, we would tell you. Anyway, so you're eligible for PR. Then there's another thing with the 4020. You actually provide this misleading information. You can't argue with it because the divorce paper was there. We told them, look, let's admit it and seek waiver for the 4020 because of child. And that's what we did. And the sponsor wrote a statement explaining her thoughts. It said, look, I did lie. Okay. But I was lying, trying to help him to get PR for my child, to stay here with my child. I didn't know you could get PR even if the relationship break down if you had a child. And that was then, visa granted. So simple as that. Waiver was granted because of child and relationship breakdown, admitted, but you can still get that granted because of child. So I already give you an example when you have access to a dependent child, even if a relationship breakdown, that's fine. But also there's family violence occurred. If family violence occurred during the relationship, you can go to PR as directly as well. Partnership, if the partner died and if 820 already got granted or 309 got granted and the applicant entered Australia, then the partner died, sponsor died. As long as they prove they have developed business, cultural, personal ties with Australia, the PR can also be granted. So those are the general things after relationship ceases. But look, I hope no one will get into the situation of family violence. But I wanted to quickly talk about it if you had that situation, because no one wants to be intimidated, blackmailed for PR and get, bullied during the relationship. If that really happens, you can't get PR without continuing your relationship. But the requirement is that the family violence must happen after the 820 has been launched. You didn't launch your visa, and you were in a relationship, you were on a student visa, and the relationship broke down, and the violence happened. Sorry, that won't help you with the visa. But if you launched it, even if 820 was not granted, family violence happened, that's acceptable. You're eligible for PR. Okay. And another important thing is that the violence must happen during the relationship. Okay. What happened is that if you apply for 820 visa, you're still within the relationship and the sponsor ended the relationship, and then family violence occurs. I would say I sympathize you. It's very unfortunate, but that won't help you to get your visa, because all of the cases they look at is there really important keys that violence must happen during the relationship. So when you try to present a case to the department, if you tell them, look, I ended the relationship, I moved out, but he chased after me a few days later and violent, hit me, etc., that won't help your case, because the department would say your relationship ended before the violence happened. So very important factor, violence must happen during the relationship. And there are two types of family violence. One is called judicially determined family violence, which is considered by the court, and the court decided it's family violence. Then you have nothing to worry about. That's end of the story. So when you're hit by your partner, don't be afraid to call the police and let court decide that. If the court decided on your family violence matter, decide that is family violence, the department cannot say no to it. But if that's not the case, not judicially determined, you may still be able to claim your family violence. It's a much more complicated process. You know, there's a definition in regulation: misconduct, threaten towards the victim, a member of family unit of the victim, and property as well. And also there are psychological violence. We won't go into the detail because it's such a big topic. But you probably need to ask a psychologist to assess if there are issues, or ask family consultant, women at risk support people if you are suffering that. Family violence does not only apply to women. If you're a man, you may be a victim of family violence. Important thing is that you may have made a lot of claim and evidence, but if the department does not accept you or believe you, or does not satisfy with all the evidence you provide, and doesn't think that your relation that is enough to be family violence, an independent expert assessment will be required by the department. So they will assign a psychologist, and the psychologist will give you assessment, and they will decide whether whatever you told them is enough to satisfy the requirement of family violence. I can tell you that sometimes independent expert can be quite biased. Particularly your English is not your first language. A lot of things can be lost during the translation, and sometimes people are biased. They just don't assume your claim is genuine. They thought you just try to get PR, and then it's gonna be hard. So remember, if you want to go there, prepare that case, okay? Prepare the case. Another important thing is that you have to decide, remember there was an element that the violence must happen during the relationship. It is not the expert's role to determine when the relationship ended. It is his or her role to determine when the violence happened. They can do that. And then it is the department officer delegate's role to decide when the relationship ended, of course, with evidence you provide. So remember, there are jurisdictions and roles of that. And to lodge that family violence claim, you have to provide a bunch of evidence. Two types from those types, like medical report, police report, child welfare authority declaration or report, women's refuge letter or assessment report, social worker statutory declaration, registered psychologist declaration, and family consultant statutory declaration, school principal, school counselors statutory declaration. So you have to prepare two of those types. You can't just prepare your own stat deck and assume that's enough. That's not enough. You won't be able to make a valid application without those evidence.